Daniel Ellsberg, you were subjected to an FBI manhunt after you released the Pentagon Papers. Today, Assange is at risk of being tortured and facing a potential 175-year sentence. Do you see parallels with your case and Julian Assange's case?
Certainly very close parallels. On the point you just raised, of course, Julian Assange is not in the potential of being tortured. He has been tortured for, I could really say, for about 8 years now, but in particular for the last 18 months, kept in a cell in isolation in a prison for terrorists here for telling the truth, at a time when he had, in the Ecuadorian embassy, already was suffering from severe pains in his shoulder, from terrible dental problems, which could not be dealt with in the Ecuadorian embassy, and the British would not give him any assurance that he would not be extradited to the United States if he left there to get dental care. I'm not aware that he's gotten the care that he needs, even now that he's in British custody all this time. So he is being tortured for that. You asked the question, the relation to my case. I was the first person charged for giving information to the American public under the same statutes and charges as Julian Assange. We do not have an Official Secrets Act in this country, as in the mother country, Britain, because we have a First Amendment, a freedom of the press, freedom of thought, freedom of association, which has always, before my case in 1971, been held to preclude either a prosecution like mine under any statute, or specifically an Official Secrets Act, which would criminalize any release of information that the government wanted to keep secret from the public. And in this case, then they tried the Espionage Act, which was meant for spies who give information secretly to another country, especially in time of war, had been used very much for that. And to use that on someone who gave information to the American public, me, for the first time. Since then, really 10 years went by before there was another prosecution. Mine was dismissed for reasons of governmental misconduct against me during the trial, criminal conduct, which led actually to the resignation of Nixon in the end, and to the prosecution, the conviction of a number of his subordinates who had been involved in that. It was another 10 years before there was another case, and then about 10 years after that, a third. Only 3 before President Obama. None having gone to one went to the Supreme Court and they refused jurisdiction. So the Supreme Court has never to this day addressed the question of whether it can be constitutional to prosecute someone for telling the truth to the American public. They haven't ever addressed that. There's a very strong constitutional case against that. Whether the majority on this court would notice that or not, nevertheless, it hasn't been tested. President Obama brought 9 such cases, 3 times more than the 3 that had been tried before. But even he did not apply it to someone unlike me, who was an official who had had a security clearance. All the other cases involved those. And try to apply it to a journalist, as the wording of the Espionage Act permits. It's extremely broad. Under earlier constitutional doctrines, that Espionage Act would almost surely be thrown out on grounds of overbreadth, because it actually applies in the wording to anyone giving, it doesn't use the word classified, but information relating to the national defense that's being protected to an unauthorized person, or reading it, or possessing it, or keeping it, any of that. In other words, would apply, the wording, literal wording, would apply even to readers of a newspaper who were warned that this is a leak of classified information. And if they give it to their spouse or whoever, and they protect it, they don't give it back to an authorized authority, as the wording of the law requires, they could be subject to this too. Well, nobody had ever tried applying the law that far. It would so clearly lead to, if it got to the Supreme Court, to a judgment of unconstitutionality, and then we wouldn't have any threat to hold over people at all in terms of legal prosecution. Obama considered using this against Assange, actually, in 2010 and 11. And remember, he gets out in 2017, early 2017. In all those years, he did not apply it to Assange because the reasons I've given, and for the practical reason that he could not explain using that against Assange and not against the New York Times. Or for that matter, the London Guardian or Observer, who used this. Assange, after all, who's not an American citizen, is being faced with extradition by the British to another country for having allegedly violated its laws on security. Now, a lot of countries have laws even a lot tougher than ours on security in China. Imagine how this could be applied elsewhere. So, yeah, in this case, then Assange backed off from charging Assange rather than charge the New York Times as well, who had published the same material. The ACLU warned at the beginning of this administration that this president was very likely to extend the law further to apply to journalists and publishers for the first time. And that is what we see with Assange. And the very fact, Jimmy, that you mentioned earlier, that some journalists have chosen to remain aloof from this on the grounds that he's not really a journalist, as Bill Keller put it, of the New York Times, not a journalist as he could see it. Fact is that if he is extradited and prosecuted here, in the current climate, I would say he would almost surely be convicted. We couldn't count on the Supreme Court to recognize that this was a clear violation of the First Amendment, and we wouldn't have a First Amendment applying to government secrecy, to national security at all. We'd have nothing but handouts from then on, and we would have more wars based on lies like Iraq and the others. So Vietnam, for that matter, in my case, the Pentagon Papers. So a great deal hangs on this. And finally, Jimmy, if I may address your question you asked, I think, Noam, why is the press staying aloof from this? To my belief, the press has been in a state of denial since my case. And that was 1971, that was 49 years ago. And I have been saying, I can tell you throughout that time to audiences of journalists, some cases publishers, AP editors and whatnot, this is a buried bomb, a mine, in effect, waiting for you. If you do not examine, investigate the secrecy system and the abuse of it, and the wrongness of the use of this law against this, it is going to be used directly against you, as well as to your sources. They were surprisingly acquiescent at the notion of it's being used against sources, actually. The legal aspects of that, in my case, were hardly ever examined, or in the other cases, which have been going on under Obama. The very frail, well, the unconstitutionality of what's being done. And so they've stayed aloof from it. Oh, this will never touch us. We have an arrangement with the government. We do our best to find secrets, and they do their best to keep them, and it works out pretty well for democracy. Well, it hasn't worked out well for democracy or for our victims in Iraq and Afghanistan, Somalia, Sudan, all these other places that are victimized in secret wars, and it hasn't worked out well for our democracy at all. So the Assange case gives journalists a chance now to focus their attention at last on the direct threat to their freedom of speech and the unauthorized disclosure, which is the life's blood of a republic.
You know, Barack Obama did not prosecute the people who ordered a torture program or carried it out. And he said the reason he wasn't going to prosecute them was because all those crimes happened in the past and Barack Obama was looking towards the future. And I guess all those people in prison are upset they committed their crimes in the future, I guess. But